Okay, Mr. Keene, we will go on the record in the matter 24 CF 252, State of Wisconsin versus Andrew Sonnenberg. The state appears through District Attorney Kevin Schmidt in person. Mr. Sonnenberg appears by video conferencing in custody in Burnett County Jail. We have Mr. Glenn Keene, Defense Counsel, in person. We're set here today in this matter for, well, it says motion hearing, but we're actually here for a status because the court did deny Mr. Keene's motion to withdraw. I denied the motion to withdraw because Mr. Sonnenberg, you have a speedy trial demand. Because of the speedy trial demand, that means we have a jury trial scheduled for April 3rd, and we have a final pretrial. The court's drop dead date by February 28th. And due to the timing of that, there is not an ability for a new attorney to get up to speed, or even for the practicality of the public defender's office to be able to locate and appoint a new attorney to your case. So that's the quandary. So the court denied Mr. Keene's request to withdraw from the case due to the fact that you have made the speedy trial demand, because quite honestly, your speedy trial demand kind of overrides the ability to have Mr. Keene withdraw from the case. So that's where we are. All right. So Mr. Sonnenberg, if you are requesting to have the court consider you being able to have an ability to have the public defender's office appoint a different attorney to your case, even though the law states that an indigent individual who is given the ability to have an attorney appointed by the state public defender's office does not have the right to choose the attorney that's appointed, and does not have the right to have the ability to have attorney after attorney after attorney. I generally allow or permit at least one time for any reason at all for a defendant to be able to say, you know what, for whatever reason, I just don't jive with this attorney and I'd like to have a different attorney appointed. Otherwise, we have to go through the whole criteria and the factors for me to consider as to whether or not this would be an appropriate place for an attorney to be able to withdraw if there would be such a breakdown in the relationship, and I have to go through certain factors. We are at a time crunch due to a speedy trial demand and having the final pretrial being February 28th and the jury trial being April 3rd, that I just can't give you that ability to have that one time, no matter what request, to be able to have a different attorney. So are you understanding what's going on?
Yeah, I was gonna ask if I do get a different attorney, can I still request a speedy trial?
Well, you would be able to at a later date, yes, after a new attorney is appointed and after you meet with that attorney and discuss the case. Yes, that attorney, after you have your initial discussions about the case, that attorney can then request a speedy trial demand. Yes, you don't lose the ability to request a speedy trial if you say, you know what, Judge, at this time, I wish to withdraw my speedy trial demand and I wish to request a different attorney. You don't lose that right to then request a speedy trial at a different time.
Okay, Your Honor. With you saying that in your words that you just said, I'd like to say that.
I just need to know what are you asking? Are you indicating to the court that you would like to continue to have Mr. Keene withdraw, and you would like to withdraw your speedy trial demand at this time? Or are you asking the court to proceed with your speedy trial demand and have Mr. Keene be your attorney?
I like to withdraw my speedy trial, and then when I get a new attorney, I like to do the speedy trial again.
All right, so you would like to withdraw your speedy trial demand at this time, and you would like the court to reconsider the request to have Mr. Keene withdraw as your attorney. And then once an attorney is appointed to this case and the attorney is able to get the evidence and discovery and look at it and talk to you, then you would discuss with that attorney about demanding a speedy trial, correct?
Yes, Your Honor.
All right. Mr. Keene, I'm going to guess that you're okay with his choice and you would like the court to reconsider your request for withdrawal?
Yes, Your Honor, that matches what you just described, matched my limited conversation with Mr. Sundberg this morning, that the reason it was denied was primarily because of was due to the speedy trial demand. I would concur that there's a breakdown in communication that makes it impossible for me to provide Mr. Sundberg with, even any legal counsel, much less effective legal counsel.
All right. So based upon that, Mr. Sonnenberg, the court will grant your withdrawal of your speedy trial demand. I will also grant the withdrawal request from Mr. Keene, as well as yourself asking him to withdraw from your case. I will grant that, and I'm going to direct Mr. Keene to contact the public defender's office to notify them that the court has granted that request so that they can get on locating another attorney to be appointed to your case so that we can keep the matter moving, okay?
Thank you, Your Honor.
All right, let's get a new date and time set. Doesn't matter which week.
I'd prefer mine.
Your week. All right, we can do March 24th. At 1:30, March 24th at 1:30, we will have a status and we'll see where we are, okay?
Thank you, Your Honor.
All right, thank you. We
Take care.
are adjourned.
The record now on file 244827SD. This is the case of People versus Jason Lee Stolt, here today for a pretrial conference on a charge of operating while intoxicated. I have just received a pretrial conference sheet, which simply indicates you decided now to plead guilty to the charge. And Mr. Stolt, is that what you've agreed to do?
Plead guilty, yes, sir.
Charge you're pleading guilty to is a charge of operating while intoxicated. Operating while intoxicated is a misdemeanor charge, carries a maximum penalty of 93 days in jail and a $500 fine. In addition to that, the Secretary of State's office will then assess 6 points against your driving record. In addition to that, it does appear you have a prior conviction for operating while intoxicated out of the state of Montana, but that is more than 7 years ago. So in addition to what the court does, the Secretary of State's office will also suspend your driving privileges. And for the first 30 days, you'll have no right to drive any vehicle for any reason. Also appears that you hold a CDL. Is that true?
That is correct, Your Honor.
If you plead guilty today, you will lose that for at least the next year. Were you aware of all of that?
I am, Your Honor.
Knowing all that, you still wish to plead guilty to the
Yes, sir.
charge of operating while intoxicated.
I do, Your Honor.
And I do have in the court file a advice of rights sheet that you signed back on January 21st of this year. Before you sign it, did you read and understand all those rights?
I do, Your Honor.
Those are your trial rights. If you plead guilty, you will not have a trial and will give up all those trial rights. Do you understand that?
I do, Your Honor.
Has anyone promised you anything regarding what your sentence will be if you do plead guilty today?
No, Your Honor.
I have not agreed on what your sentence will be. Knowing that, you still wish to plead guilty.
Yes, Your Honor.
Anyone threaten you to force you to do this?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
And finally, are you pleading guilty to this charge because you believe you're guilty of this charge?
Yes, Your Honor.
This case was initiated through a citation written by the Otsego Police Department. It dates back on December 20th of last year, 2024, at approximately 5:52 in the evening. You operated a motor vehicle on West Morrell Street within the city of Otsego here in Allegan County. Were you operating a motor vehicle on that date and at that location?
Yes, Your Honor.
Before driving, had you been drinking alcohol?
Yes, Your Honor.
Did you take a breath test or a blood test in this case?
I took a breath test, Your Honor.
What was the result of your breath test?
A 0.187, I do believe.
Based on that, I will find a factual basis. We'll find that your plea is knowing and voluntary. Your plea will be accepted to the charge of operating while intoxicated. And for the record, I have received an assessment that was performed through Michigan Assessment Services. I'm going to take a moment to review that right now. Have reviewed the substance abuse assessment. Again, a criminal driving history was already contained within the court file. So with that, able to proceed to sentencing this morning. The pretrial conference sheet completed by the prosecutor's office also just recommended a sentence of probation with standard conditions. They were not recommending any jail as part of the probationary term. So with that, Mr. Stolt, this is your chance to tell me anything you would like to for your sentencing.
I just want to apologize for, making a bad decision. My actions are reprehensible. I just want to be a positive role model for my family, my friends, loved ones. My actions on the 20th of December are unforgivable. I could have done so much worse that day. There hasn't been a day since then that I haven't thought about it. I could have really changed someone's life. I could have killed someone, myself included. I could have left my kids fatherless. My actions are they're unforgivable. My apologies for just making an awful decision. I will say that I am grateful for the victim impact videos and stuff like that, because it really kind of sets you in your place to let you know or show you or remind you of what really could have happened if things were worse. Specifically the father whose son is now handicapped due to a drunk driver. So again, my apologies for just messing up, and it is definitely the biggest and worst thing I've ever done in my adult life. I'll live with this forever. I have to live with the fact that my kids saw me. And yeah, I hope everyone can forgive me, and a lesson learned, and move on and take this with great stride, not to ever let emotions get a hold of me again. And that's all, Your Honor.
Well, just to make sure I've got the facts right here, because I didn't order any kind of a pre-sentence investigation. All I have in front of me is the court file, which is just a ticket. And I did notice that you live way up in Kent County, in Caledonia, and this occurred in a residential street in the city of Otsego. So I was a little wondering what happened here. And according to your assessment, you showed up on Morrell Street for a parenting time exchange with your ex-spouse.
That is correct.
You were there to pick up your kids?
I was there, to confront her because they were coming up that evening.
Okay, and then how, just out of curiosity, I gotta imagine that's what, a good, I don't know, 25, 30 miles back up to your residence?
Roughly, it's about a 35-minute drive.
Okay, so you showed up to pick up your kids with a .18, and you were gonna try to drive them all the way back to your residence, but your ex-spouse called 911 on you, and that's how you're here.
That is correct, Your Honor.
You are correct that this could have been a whole lot worse. So, okay.
Absolutely.
Mr. Barracks, on behalf of your client?
Your Honor, he's 43. He does have a prior, but it is 17 years ago. He has not had a drink since the date of the offense back on 12/20. He's gainfully employed. He's been a forklift mechanic for the last year and a half with Crown Lift. He did do the hour victim impact panel, as well as the 4-hour highway safety seminar. we would just ask that you follow the recommendation of the prosecutor.
So it sounds like, Mr. Stoll, you're gonna be able to be employed, even without a CDL?
That is correct, Your Honor.
You just won't be able to drive to and from work. You're aware of that?
I understand, yes, Your Honor.
Okay.
Oh, and he did come today to, prepared to pay in full all the fines and costs today.
On this charge, as a repeat offender, we'll place you on probation for a period of 1 year, and that will be with substance abuse counseling as directed by the probation department. Standard condition of probation: do not possess or consume any alcohol, marijuana, or illegal controlled substances while on probation. They will have the authority to check you for that here at the probation department. They will have the authority to have you checked by the police at your home up in Caledonia. And for the reasons as already stated on the record, I am going to order physical monitoring for the first 30 days of your probationary term, utilizing either the scram or solo link methods at the discretion of the probation department. Will indicate the requirement of a victim impact panel has already been completed. Again, in the next probably week to 10 days, you'll be notified that your driver's license is gone for a period of time and that your CDL will be gone as well. Specific condition of your probation is that you not drive without a proper valid driver's license. The charge of operating while intoxicated, the fine is $500. Court costs are $400. State costs and fees are $125. There is a $360 oversight fee for that 1 year term of probation, for a total of $1,385. Court file is showing that you were released from the Allegheny County Jail on a $500 PR bond. So all of that is due. You will have, if you would like, the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. Finally, required to advise you pursuant to MCL 771.2 that you are eligible to be discharged at the halfway point of your probationary term if all the terms and conditions of your probationary sentence have been completed at that time. So in your case, you could have probation all concluded in as soon as 6 months. Probation department's going to call you and set up that probation order. I'm not sure if it'll be yet this morning or this afternoon, but during the day today, what telephone number can they reach you at?
It'll be area code 406.
To confirm, area code is 406.
Correct.
Is that still a Montana area code?
Yeah, yeah,
Okay. And then, is that correct?
that is correct, Your Honor.
You are free to hang up the court proceeding, be available at that telephone number. You'll be receiving a telephone call at that number from our probation department. Good luck to you, sir. Thank you, Mr. Caldwell.
All right,
Your
thank
Honor.
you.
Be safe, be well, sleep sweet, and much love.